So one interesting aspect of this agreement is it's trying to cover a lot of bases.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, law professor turned online educator Michael Bloom walks through the confidentiality section of Microsoft's Partner Network Agreement. He balances a contract drafter's desire to use broadly applicable principles with the need for precise language. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose of this show is exactly what it sounds like. We take contracts, we beat them up, we are often mean to them, occasionally nice, but not really. I'm hanging out with my buddy Michael Bloom. Michael, how are you today, sir?
Doing well. How are you, Mike?
I am pretty good. The weather is cooling down. My plants are dying. I had a midlife crisis in the middle of COVID, and I did what all white guys did and started a garden and a podcast. And so it's all going well as the weather cools. But today we are digging into, speaking of midlife crises, a document. We could talk about my quarter life crisis that took me to law school and contracts.
Different podcast.
Right, exactly. This is a different show. But yeah, we're talking about this document. I'm going to show it to him real quick here, Michael. And this is the Microsoft Partner Network Agreement, which is a fascinating document. So tell me, Michael, why are we talking about this? What is this document? When are we going to see something like this? Why are we talking about it?
Yeah, so it looks like the Microsoft Partner Network is this everything under the sun potential way to work with Microsoft, covering things from manufacturing to software development to sales and marketing, et cetera. And so one interesting aspect of this agreement is it's trying to cover a lot of bases. And we'll dig into that today when we focus on the confidentiality piece of it and see how they attempt to make that section work across all of those different scenarios.
That's right. We will focus on the confidentiality section. But before we do, tell us about you. What's your background? What are you doing in business now? Why are we talking to you about this kind of document? What's your background?
Yeah, so I was a clinical professor at Michigan Law School. Before that, I taught at Chicago Law School. Before that, I practiced at Sidley in Chicago doing M&A and technology transactions. And while I was most recently teaching at Michigan, teaching a transactional clinic, I wanted a way to get my students up to speed on the language of contracts more efficiently so they could get going in the work that I was supervising them in the clinic. And so I wanted a Rosetta Stone, a Code Academy, a Team Treehouse, pick your favorite language learning application, but for learning how to read and write contracts, just to use in my class. And this was about 7 years ago, couldn't find it, so started to build it with whatever I could find. And now fast forward, major law firms are using our online training tools for training up their incoming associates, their laterals, their mid-levels, their summers, sometimes their paralegals, et cetera. It's a good time to be in the remote learning game. So we're, taking on new law firms every month here.
That's very cool. Side story. Somebody from Michigan Admissions called me when I applied to different law schools. I was living in Austin at the time. And they said, hey, we want to give you a spot to go to Michigan, but you live in Austin. Are you, we don't want to burn the spot if you're just going to go to UT. Are you going to UT? And I said, well, let me ask you this. What's the temperature outside right now? And she was like, it's 12 degrees. I'm like, I am going to Texas. So that's what I did. So good for you pushing through the weather. Well, so this document, as you mentioned, covers a lot. This Microsoft Partner Network is basically every way that you want to work with Microsoft. You want to be an affiliate, you want to be a developer, other tools, Apple or Amazon, they've got separate, spaces for each of these. Microsoft is just like, you want to work with us, here's where you have to go. So that's this context to this document, which makes this confidentiality section interesting because you're potentially getting access to all kinds of information. So let's start with that, the confidentiality and publicity section. If we scroll down, A's got some background stuff. B starts digging into what holds, what is confidential information. And if we go to 1B, it says, given the nature of the disclosure or circumstances surrounding the disclosure, the receiving party should treat as confidential. Meaning, I take this as like, here's a background rule, don't be an idiot. What do you think about this kind of language?
Yeah, so, and this is a place where we're seeing this tension between wanting to have a simple all-purpose agreement and also hopefully it's clear and applicable to each situation. So here they're taking with B a pretty broad approach to defining confidential information, sort of, you know it when you see it. If it's the kind of thing that ought to be treated as confidential, then it is confidential. Hopefully that's, firing off light bulbs for folks. That's something we might argue about. It seems like it's confidential to me, but not to you. There's certainly room here for disagreement and potentially dispute if it gets to that point. But the trade-off is having language that's flexible, more of a guideline that is more or less going to work across different scenarios versus a more rules-based approach that's specific and tailored to the situation, but would require them having different agreements or editing the template for each different relationship.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Yeah, and I should point out, we talked about this a bit in preparation for this conversation. Microsoft has fairly famously worked really hard in principle to try to narrow language of documents, to keep them simpler, to even keep them visual. I've got some friends who are at Microsoft actually who are doing this, and they're hiring for really interesting roles in contract management and contract creation. And so in the background, you've got this effort to, hey, let's talk principles, instead of spelling out every little thing. But I think, to your point, in the background, there's going to be this, did we do it, right? Like, did this general principle of don't be an idiot, does this serve the purpose? Go into 2 under B. It says each party must not disclose any confidential information of the other for 5 years following the date of the initial disclosure. However, there is no time limit regarding the disclosure of confidential information that contains personal data. What do you think of this section?
Yeah, so a few things here. One, the first thing that struck me is what's not said here. Normally, in a confidentiality agreement or a section on confidentiality, there's 2 core obligations. So after we establish what counts as confidential information, that's what we just went over in 1, then it's, well, what can and can you not do with that information? I would normally expect to see a non-disclosure restriction, which is what we do see here, and a non-use restriction that limits what the other party may do with your information. So I'm pretty surprised to not see that non-use piece here. That's the first thing I would call out. The next thing here is their approach to how long you have to not disclose that information. 5 years, fine. That's, depending on the industry and the market, that might feel a bit long. But the mechanism of from the date of initial disclosure is certainly something you see. It is a clunkier approach than saying from the effective date of this agreement or some other fixed point in time. Because theoretically here, you have to track every initial disclosure of every bit of information, and that's also challenging. How do you define, how do you draw the boundaries around this bit of information and that bit of information to trigger each 5-year term, and then who's keeping track of that? Obviously, nobody. So it's administratively complicated if you were to attempt to actually follow this to the letter. Realistically, no one's going to. And it's not right or wrong, but for an agreement that's trying to be flexible and easy, this is a bit of a surprisingly complicated approach to, creating a bunch of these parallel terms for how long you have to maintain the confidentiality of this information.
Yeah, and in the next sentence, we'll give you guys the full block. I won't read it all, but in this effort to sort of talk like people, it might be creating some confusion. It says the receiving party will not be liable for disclosure of information. And then it gives a list, like it already knew it, or it came from a breach that it wasn't your fault, or you developed it independently, or it's just not your fault. What do you think of this kind of sentence? This will not be liable for section?
Yeah, you see it this way sometimes. I think the more effective approach to carving out these types of information is to exclude it from the scope of protected information in the first place. So in this example, it would be moving this up to number one, where we're defining what confidential information is. Let's also talk about what it's not. So it's not information that you already knew or that's already publicly available. These types of exceptions are relatively standard and fine. They work. But it's not, usually we're not just trying to say, hey, you're not liable for these bits. We're saying it's just not covered in the first place. So every time we talk about capital I, capital C, capital I confidential information, we're not talking about these things that you already knew or that you independently developed. And then that way it just flows through nicely the rest of the agreement wherever that term is used. Right. So maybe it's okay here, but I would, when I see this approach, then you have to comb for every place where confidential information is used and make sure that it's okay in those instances that it is applying to, information you did independently develop or these other carve outs. It's not using the mechanics of the document as effectively as you could be.
Yeah. And I mean, my totally ignorant question here is like, using that term liable is almost like creating a legal definition inside of a document that you might litigate later. Why create that, right? Like just create the carve out that says this language, but at the same time, that may be what the reading party actually cares about. They might actually say, right. I want to know what I'm liable for. I don't care about your legal definitions. Tell me what category. So, to your point, I think I could see writing this either way and having an argument for either way.
Yeah, it's a bit of a blunt instrument, right? It's like, oh, by the way, you're not going to be liable for all these things. I don't care what anything else says. Typically, I would rather work through the structure of the agreement. So you're only taking on responsibility here. You're only taking on legal obligations and liability for information that we're defining as confidential information and then imposing restrictions on. Right. So this is sort of, hey, who cares about that edifice? But before we move on, let's just be clear, you're not liable for any of these things. It might get you there. I'm not saying it's a terrible approach. It's just not working through the structure of the agreement as tidily as you might want to see.
Well, and structurally in 3, they go to this next point where they say, but what if you have to, right? What if a court says that you have to release this information? And again, they seem to focus on principles. They say you give the other party notice, but it says, the disclosing party must seek the highest level of protection available. They don't define what that level of protection is, but there's this principle. They're trying to just, keep driving home these principles and sort of awkwardly tying to the other sections. What do you think of 3?
So 3 by itself, I mean, we could quibble, I'm sure, with language in here, but I think it's fine, right? This idea, also very common, is what you'd expect to see, this idea that if the government comes a knocking, you're stuck between the rock and the hard place of your obligations under this contract and your desire to not go to jail or be punished by the state. Okay, fine, you can cooperate with the state. We're not going to hold you in breach of this contract. And then goes on to say, but hey, here's the things we expect you to do. However, if you can get some kind of confidential treatment from the judicial body or the administrative body or whoever is coming a knocking, then do that as much as possible. Seek to obtain it. So I'm okay with that. The part here that I don't love, the relation, and reasonable people reading this casually probably don't pick up on this, but we want the relationship between our obligations in 2 and this essentially exception in 3 to be made explicit, so that, because right now, theoretically, you could breach 2 while you're cooperating with 3. Now, again, reasonable people, if we ended up in that situation, we'd say, okay, we know what they meant. It must be that if you're operating under 3, then you can't be breaching 2. But better, and what you do often see is, in 2 saying except as permitted in 3. That way, just all the parts of this document are just playing nicely with each other. We don't have a literal conflict on its face where, hey, I'm just cooperating with the court order. In 3, you said I could. And now you have this gotcha in paragraph 2 where I disclosed and I said I wouldn't. Yeah. And so I would just want a couple words in there making clear. I'd probably put it in paragraph 2 where we're saying, hey, you must not disclose for 5 years except as permitted in paragraph 3.
And then 4, sort of awkward. it has the feeling of something that was created because something happened. But you're not quite sure that this is always going to happen. It says neither party is required to restrict the work assignments of employees who have had access to confidential information. And it goes on talking about how employees will use things. Neither party will bring a claim under trade secret law, et cetera. What do you think about 4?
I agree with you. There's a story behind this paragraph. It is awkward as presented. So I presume what they're trying to get at here is sometimes called anti-lobotomy clauses or residuals clauses. This idea that through this relationship, you're generally going to get smarter. Your general know-how of your employees will benefit from this relationship. And we're not expecting you to, cut off part of their brain or somehow, how could you even not use that, improved skill set or improved general know-how in other similar things in the future. So I presume that they're trying to get at that by saying, with this language here. So you're not required to restrict the work assignments. My question there is, okay, I never thought I was. Are you telling me that I have this permission that I already had? That feels strange. And begs that question, why? And okay, do you have to tell me everything else that I already thought I could do? So it creates a strange inference that might actually be harmful, even though this is trying to be, helpful. So there's a tension there in the contract. This is a tough rub because, on the one hand, you want to say, yes, their general knowledge, go ahead and use it, but don't use my information. And how do you draw that line between what is this permitted, more, nebulous knowledge that you've gained versus specific information protected by this agreement? And then that second sentence, neither party can control the incoming information. I just don't know what that sentence is doing. What I mean by that is I don't know the work of that sentence, the purpose of that sentence in this contract. Is it a statement of fact that the both parties are just agreeing is the case, that you can't later argue that you have this control, or that the parties are relying on that they don't have this control? Is it an obligation such that if you went on to somehow control that, then you've breached the contract? I honestly don't know. I'm not being cute. I don't know what that sentence is doing. And that's dangerous because then later on someone could say, oh, you've breached this. Maybe it starts off as this acknowledgement of information. That was the intent, but it could be argued later to be a covenant that you've breached because you went ahead and did control the incoming information. I assume it's an acknowledgement that the parties are saying, hey, we understand. We're not expecting that either of you will control what information is coming in, and back to this idea so that, employees might just get smarter by virtue of being on this project or being engaged in this relationship. And we all understand that that's just the nature of it, and we're not going to cry foul later.
Yeah, it reminds me of arguments with my wife where theoretically, the less I say, the less likely I am to say the dumb thing that's going to extend the argument. Now, that doesn't mean that I recognize that when I'm in an argument, because I went to law school and think I can argue really well, but it does not matter in an argument with my wife. So before we move to the general principle, tell me about C. The section was called confidentiality and publicity. What's C doing real quick?
Yeah, actually, before we do that, there's the last sentence in 4.2 I want to touch on as well. You do see this idea. One way you sometimes see parties try to draw that line between information that's protected and specific versus information that's more general and you can continue to use it. And one way you often do see this line attempted to be drawn is this idea of unaided memories. That might be okay in this context from the disclosing party's perspective. I don't know that it's a solution for all cases. So for example, the textbook example of the Coca-Cola recipe protected behind how many layers of vaults and worth so much money. If you get access to that, which presumably that kind of information is not being disclosed here, but if you did and you memorized it, am I cool with now you using it and no claim for trade secret misappropriation? Of course not, as if I'm representing Coca-Cola there. So unaided memory might be a fair way to draw the line with the type of information that might be at stake, but it's not a silver bullet solution in all circumstances. And I think it turns on how realistic is it that someone could memorize the thing, and how valuable is it if they were able to walk away with that, in their unaided memories.
And C?
Yeah, so C is getting at that second part of the title, right? So up until now, we're talking about confidentiality, working through, more or less classic types of provisions you might expect to see in a confidentiality section. C is getting at this idea of publicity rights. So usually talking about either party's right to make known to the world that they're working with the other. Press releases, logos on websites, customer lists, that sort of thing. And this could be drafted either way, just depending on what the deal is. Sometimes that part of the deal is it's really critical to be able to publicize the relationship, and then this would be flipped that way. In this case, they're agreeing that neither party may publicize unless they go on to agree otherwise. And I don't see any big issues there, except the stray business integrity principles added at the end there that I'm sure is intended to be part of the next section.
Just put that in there. Look, I want to ask you a big picture question, and I want to get to it by making a terrible analogy. When I practiced, my partner and I, we had a bundled service that was a certain price. Let's say it was $5,000, and we wanted to serve the justice gap, and so we were trying to decrease the price to like $3,000. That was our target, right? So whatever that is, 40% less or something. And the work that we had to go through to take out that 40% was, just backbreaking. But then we found that people who don't have $5,000 don't have $3,000, right? And I sort of feel like with documents like this, I love the noble effort of let's take a 50-page document and turn it into a, whatever this is, 13-page document or something. But I'm not quite sure that a person who's not going to read a 50-page document is going to read a 13-page document. And what are we losing in that? This is not a critique of this specific document, but there is, I think, a big picture general principle question of, if we make this effort of trying to narrow this down and trying to get it to the point that somebody will read it, is that a realistic aim? If it's anything more than a page, right, have we gone too far? What do you think about that? Can we meet that goal of condensing this kind of information down?
Yeah, I think it's a great question. So with any effort like that, it starts with, like you're alluding to, audience and goals. Who are the users? What do we want them to use this work product for? I think in general, taking the bloat out of documents, making them easier to use generally is a worthwhile endeavor, even if that means that most people are still unlikely to read the document. I think sometimes with projects like that, the focus gets laser zoomed in on cleaving out, legalese, which I'm not saying that's a bad thing. That's a good thing. That's part of the effort. But also part of the effort of taking out bloat is figuring out how to efficiently create a logical structure in the agreement and then efficiently use it.
Right.
That's a little bit harder. Right. And requires, reducing the fraction and thinking about ways you can design the document more efficiently. I would argue that's equally, if not more important than taking out the legalese and speaking in plain language where doable. And then with a technical document like a contract, I wouldn't want to leave on the cutting room floor a couple extra words that makes literal and precise how all the parts work together. Right. So just the example we talked through here, how paragraph 2 and paragraph 3 work together. I would not want to leave on the cutting room floor things that make really explicit what these words that we're writing down are doing. Is this an acknowledgement? I would say then the parties acknowledge the file. I know that's a couple extra words, but it helps to make clear that we're not creating an obligation, something you have to do. We're just saying that as of this point in time, we're agreeing this is the case. Right. That's helpful so that in both cases, we're thinking about the lawyerly exercise of what are the future arguments my worst enemy might make. I shouldn't just throw lots and lots of paragraphs in there to try to protect myself, but I should nimbly try to, forestall those arguments, make this document really logical, clear and clean, and clear on how all the parts work together. So that structural aspect, I think, is harder work and sometimes overlooked in these exercises. That's one big thing. I think the other big thing is this trying to be all things to all people, all things to all circumstances.
Right.
Now, sometimes that might be worth it. I don't know enough about this context. Microsoft might be saying, look, this is low stakes. We're not sharing the Coca-Cola recipe. We want something in there to protect both sides, real plain vanilla stuff. And that's it. It's not worth having five different templates to manage.
To nail that, from what I can tell, this thing covers both. You are an IT local company doing Microsoft approved services, and you're a dude with a website who's got an affiliate link on there. And in my background pre-law was in logistics and shipping and trucking. And, you'd have one kind of contract for the company that's like the shipping company, but then dude on the dock, he's got a one-page purchase order, right? And so to your point, this feels like a document that's trying to cover two different scenarios that, in fact, the audience, as you said, is a very different kind of engager with documents like this.
Yep. Yeah, exactly. And again, maybe that's the right approach for Microsoft here, because they don't have to manage 50 different documents instead of just one. And given the risk profile and how this is being, that might be more efficient, and where that kind of cost benefit analysis comes down for them. So it's easy for us or me to kind of come in sideways and say, oh, this could be tighter here, this could be tighter there. But I'd say even trying to be all things for all people, or drawing the line the same way they're doing it right now, we could still, as we've discussed a few examples of, tighten up the language here. So it might be leaving, for example, the 1B, given the nature of the disclosure type approach, even though that's a bit vaguer and more flexible, but that allows it to work across. But adding the non-use restriction, tightening up the relationship between 2 and 3, for making clear the what 4 is intending to do. That could be a way to kind of have your cake and eat it too here. Yeah,
the nature of making conscious decisions out of things that we used to just copy and paste means they can constantly be improved. And again, the people I know at Microsoft, I think they know that, right? And they're doing that work, and I think that's great. So to get to you thinking about what your company does and what you're working on, if people want to learn how to make these kinds of decisions, to think about things like structure, to constantly improve their base of contracts, what's the best way to connect with you?
Yeah, so Praktio.com, Praktio.com, I assume that'll be on the screen here too, is a great way to learn more about the company. You can contact me a bunch of different ways through the site. Main use cases so far the last few years have been training up incoming associates, training summer associates at large firms. We've more recently got into training procurement departments at global companies. And we're always adding new products and serving new use cases. So if we don't do something that's something that you think would be useful for what you're up to, we'd love to hear that and potentially come up with something new.
Right. Throw money at us. We'll fix your thing. I like it. Well, I appreciate that. Michael, thank you for being with us. And all of you watching, thanks for hanging out with us. All of the information on this episode, including a link to this particular document, will be over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show and be mean to contracts like Michael and I are, just email us. We are at community@lawinsider.com. We will see you guys next time. Thanks again, Michael. Have a good day.
Thanks, Mike. You too. Take care.